The United States of America will no longer accept birth certificates alone as citizenship proof under Donald Trump's orders. The United States of America will no longer accept birth certificates alone as citizenship proof under Trump's orders. Welcome back to the channel. I said that twice so that you are aware of the piece of information that I am about to give to you. This is another United States of America immigration update video. If you want to stay in line with all the latest U.S. immigration updates, just click the subscribe button and click the bell next to the subscribe button so you are notified every time a new video goes up on SouFLoTV. U.S. born kids will now have to prove that their parents are U.S. citizens or green card holders under Donald Trump's birthright citizenship order. You may have seen recently where the courts voted against Donald Trump U.S. birthright citizenship act, what he was trying to do with it. However, he lost some, but he won some. And the USCIS is getting ready to implement one of his EOs or executive order. Let's talk about it. So, President Donald Trump attempts to limit birthright citizenship that was ruled unconstitutional by a second U.S. appeal court, making another setback for his strict immigration policies, which may ultimately be determined by the U.S. Supreme Court. Now, 5 federal courts have rejected President Donald Trump's executive order that is aimed at ending automatic citizenship for children of individuals in the U.S. illegally or temporarily. 5 federal courts have rejected that. Basically, what the courts are saying, if you're born here on American soil, you are American, regardless if your parents are illegal or not. Well, the U.S. Supreme Court is expected now to deliver the final ruling on that particular one. U.S. citizenship is currently granted to all Americans who were born newborns. However, President Trump's executive order on birthright citizenship could change this by affecting the eligibility of all newborns in America. Implementation plans are being formulated, but the courts have yet to rule on this order. President Trump's executive order limits automatic birthright citizenship to children who have at least one parent who is a U.S. citizen or a lawful permanent resident with a green card. So, if both your parents are illegal, you will not be getting U.S. citizenship. Both parents are illegal, babies are born today, they'll be picking up the citizenship of one or both of their parents. But this eludes those with illegal presence or temporary U.S. parents, such as H-1B foreign workers, F-1 study visa holders. Them too will not be having children in the U.S. who will be picking up citizenship here. If you're here on a temporary visa and you have a child here, a work visa, H-1B visa, which is the visa that a company would pay for to have you come work here. If you find the love of your life and you get pregnant here and decide to have a baby here, your child will be the citizen of where you come from, not the United States of America. So following the implementation plans of the Department of State and USCIS, the Social Security Administration has announced its strategy to execute the president's orders once it is in effect. They are rolling with it. Social Security numbers are assigned under the Social Security Act to ensure proper management of wages and earning data for Social Security Program administration. They are also granted to non-citizens eligible for work in the U.S. regardless of citizenship status. Now, according to the Social Security Act, applicants for a Social Security number must provide sufficient proof of citizenship or foreign status. Currently, a birth certificate indicating a U.S. birthplace can confirm citizenship. Currently, however, this is likely to change once this executive order is implemented, which Social Security Administration and USCIS are both getting ready to implement, potentially requiring more documentation. When and if it is implemented, once it is enacted, birth certificates indicating that you were born in the U.S. will no longer serve as adequate proof of U.S. citizenship for individuals who were born thereafter. The SSA, Social Security Administration, will mandate evidence, meaning making it mandatory that you have to provide other evidence of at least one of your parents who must be a citizen or who must hold a eligible immigration status at the time of that child's birth. That means mommy or daddy is going to have to be either a US citizen or they'll have to be a green card holder, permanent resident. Essentially, the SSA, Social Security Association, will require proof of a person's birth, indicating that their parents were US citizens or that they were green card holders at the time of the child's birth. Now, here's what will change. So once this executive order takes effect, the Social Security Administration will revise its internal manual to provide the Social Security Administration will continue to abide by existing regulatory evidence requirements for the applicant while also requiring acceptable evidence to demonstrate that at least one parent in the U.S. must be a citizen or in eligible immigration status. Green card holder. These instructions would set out steps to be taken when 1. The applicant parents do not apply for their children's Social Security number through the Enumeration at Birth program, and 2. Parents or applicants seek certain replacement cards. Now, additionally, evidentiary requirements that a parent must provide for a mother or father that was born before that executive order takes effect, acceptable of U.S. citizenship includes a Social Security numbers record of both or either parent that indicates citizenship or a U.S. place of birth. So you literally are going to have to show up with your parents' birth papers for a mother or father who were born after that executive order took effect. Acceptable evidence of U.S. citizenship includes a certificate of naturalization, a certificate of citizenship, a U.S. passport that was issued per the executive order, or a U.S. citizen identification card that was issued by the Department of Homeland Security, or a consular report of birth, or other verification from the Department of Homeland Security, U.S. Department of State, or federal or state court records confirming citizenship, or documents establishing a U.S. place of birth, plus evidence of parents' U.S. citizenship or eligible immigration status. Wow. If you're having any problem understanding any of this, then please listen to the video all over again. Now, if the applicant's mother or father alleges lawful permanent residency, then the acceptable evidence of lawful permanent residency will be an Social Security number record or either parents that indicates they are a lawful permanent resident. The U.S. green card holders can demonstrate their status by presenting the permanent resident card or Form I-551, a machine-readable immigrant visa that's called an MRIV with temporary I-551 notation, or other verifications from the Department of Homeland Security or federal records confirming lawful permanent residence. Furthermore, if an application's or an applicant's mother claims lawful permanent presence, she must provide evidence like a Form I-94 that verifies asylum or refugee status that was granted under the law. Anybody outside of that, you will take the citizenship of one or both of your parents. And that is the latest in U.S. immigration update. Leave a comment in the comment section below, and I'll catch you on the next video. Hit that subscribe button, and to stay tuned to all the latest U.S. immigration updates, hit that bell so you are notified. We'll catch you on the next video. I'm out. Peace.